Okay, let's get this rolling. So you guys know how this works. For 30 minutes, you get access to me for 5 to 7 minutes per call. And basically, you get to ask me about Social Security disability insurance questions or supplemental security income disability questions. But the main focus are disability questions under Disability Resolution Law Firm. We're going to be taking them directly into this phone. Remember, no story mode when you call in. Get right to the legal question. Also, use a fake name throughout the process. And finally, we don't go super deep because I don't know your whole file. So just expect me to do general information. Now, with that said, let's get this thing rolling. I'm going to go ahead and put the phone number into the chat area. Load your chat questions up right now. We're only going to be doing about 30 minutes because obviously I want to get to bed right around 2 a.m. We are working on a holiday. It is Thanksgiving, which is why the turkey is in the thumbnail. Now, with that said, if there are no callers, because it is a holiday in the middle of the night today, then what I would say is this. I'll go ahead and go to bed early. I'm going to start the countdown basically in about another 10, 20 seconds, because I know when you start these videos, sometimes they do an ad, stuff like that. So I'm going to go ahead and start the countdown shortly. Let's go ahead and begin it. So if nobody calls in within the next 10 seconds, and remember when you call in, fake name, no story mode, legal question up front, you get 5 to 7 minutes. No, and don't stack your questions. Like you can ask one additional question, but don't be like, oh, I have another question, I have another question, I have another. Don't do that. It's not fair to the other people. But with that said, we're going to start the countdown and begin the process to see if nobody calls in because it is a holiday. If nobody calls in tonight within 10 seconds, then I will go ahead and go to sleep because it is super late. All right. 10, 9. I should get like little ball that drops. 8, 7, 6, 5, 4. Am I going too fast? Probably 3, 2. Oh, there's a call. Hold on. Here we go. We have speaker on. This is Attorney Walter Hnot. We are live. Remember to mute the video on your side so we don't get feedback. And do we just talk directly through the phone? Attorney Walter Hnot, use a fake name. What is your legal question? Go ahead.
Name's Matt.
Perfect.
So my ALJ, so she requested that a neurologist, sorry, let me back up. I have a big box city legal rep,
yep.
And she requested, I'm 42, I have several damaged discs, and they're requesting a neurologist look at my files. The neurologist doesn't necessarily think I'm disabled, even though I had a second surgery I turned down in the lumbar, and a spinal fusion that was canceled. And I'm just wondering what the odds of me getting approved are.
I mean, all right, so not a lot of information. Haven't seen your medical record. What's your back doing nowadays?
I had a spine surgery that was canceled. It needs a fusion on L5S1. It has a collapsed disc with severe stenosis, severe spondylosis, and I believe the L4 has similar issues.
Okay, so considering that, walk me through, what are your other top 5 impairments?
Anxiety and depression.
Okay, when did you stop working the last job you did, and what was the job?
I was a desk IT guy, and I pretty much stopped working right after I hurt myself. It was nearly 2 years ago to the day on December 23rd.
Do you have any additional failed work attempts where you tried to get another job and got fired?
Yes, sir.
Okay. How many additional failed work attempts do you have?
I have one.
How many surgeries have you had on your back?
Just the one.
When it comes to medication, what kind? I gotcha. What kind of pain medication did they prescribe you?
I've been on everything from gabapentin, Lyrica, oxycodone, Norco, a few others I've missed.
Okay. Talk to me about ambulatory devices that you've been prescribed by a doctor that help you get from point A to point B while walking.
I was given crutches in the ER, but I'm not sure what medical need has been documented on their behalf.
Okay, but you're out of the ER now. I mean, do you use a walker, wheelchair, canes, crutches? What are we at? Yeah.
I use a crutches past 30 feet.
Okay. So, I mean, if the back was really that severe in that point, you needed a fusion, you'd be in a wheelchair or you'd be sitting on a walker half the time. So When you say really severe, what are we talking about millimeter-wise?
16.
Oh, okay. All
I
right.
think it's 16. That's what I saw on there. I'm not sure what they're measuring, though.
Talking about the mental side, when was the last time you were inpatient on a mental facility, like a behavioral or sanatorium?
Years before the current situation.
Do you go on a monthly basis or more than a monthly basis for review?
What type of review? I don't know what that is.
Psychiatrist, psychologist, behavioralist?
Weekly.
Weekly. Okay. What are they saying in the notes?
A lot of things that are beneficial on my behalf. I have 2 different function capacity reports from my primary care, which no one cares about. I did get a function capacity report from my surgeon, and the therapist says I have severe depression due to the situation with some suicidal ideation.
I'm hearing therapist. We talking master's level or doctorate level?
LCSW.
Okay, so this is all about the back with a little bit of the mental kind of thrown into the mix. All right, so let me ask you this: when it comes to the back, what are the things that you do that result from you not being able to do, regular activities, cooking, cleaning, laundry, paying bills, buying groceries as a result of your back? How do you make it happen? The workarounds as a result of your back being impaired?
Well, I get a lot of care. I have some people cooking for me. I don't put on socks and shoes. I don't get to bathe regularly. I do need grab bars around the house. I generally don't move much and spend a lot of time in bed.
So, how much time do you spend in bed?
About half the day. I don't get to stay asleep very long before I get woken up, so I have severe sleep deprivation right now.
When was the last time you had a sleep study?
I haven't had anybody refer me for one. I did have at least a 6-month journal of sleep notes for the ALJ as far as evidence goes. And then I did have an anxiety problem. I have ADD, and it manifests as severe anxiety disorder that's been treated, but I can't get anxiety meds and pain meds at the same time. So there's some sort of additional suffering I'm enduring that. I don't think that they care at all about any of that, do they?
Well, they do, but, it has to be notated. All right, so, and you say your age was 42?
Yes, sir.
All right, so what's your percentage passage rate for the judge? Or which judge do you have?
Josephine Arno. As of now, she's 50-50.
All right, so it's 50. All right, so if you looked at the percent passage rate and you're 50-50, it's a pretty good chance that you're going to be approved so long as your medical record is what you say it is. I'd put you in the 65 to 75 percentile range for potential approval out of 100. But, remember, I'm not seeing the bad stuff that if I read through it, I go, oof, you know what I mean? Like, I'm not seeing the smoking, the alcohol, any use and abuse stuff. So, I don't know what's in there, but I know if you got
one note of some drug abuse, but there wasn't anything else significant. It wasn't noted as a problem. It was just in one file. I didn't have any sort of incidents. I watched all your videos since the moment I became injured. I somehow stumbled into you.
Sure.
So I did a lot of precautionary evidence collecting and made sure I didn't say certain things inside the doctor's appointment. So there shouldn't be any of that aside of, the mention of I got a few pain meds from a family member.
What's it like when you buy groceries?
I use the crutches to get into the store, then I use the little cart. And that was one thing the ALJ asked about. I told them I used the crutches to get to the store and the little cart to get around. But that's only half the time. My uncle shops them and the other half the time.
And the judge is sending you to an additional CDR, correct? Or no, an additional CEME.
Well, they're not looking at me. They just looked at my file, and my legal rep is doing interrogatories. They're doing what's called a pro offer right now, and I don't know I've never heard you mention that before, so I don't know what that is.
So, well, okay, let me ask you this first before we go into that. The CE, the consultative examination medical expert appointment, you said that they're setting up an additional post-hearing, appointment for you. What?
I never actually had a CE, and they're sending my file to be reviewed by one of their medical experts, is what my rep is telling me.
So what's happening is you're going to a disability consultant. The disability consultant so you're not physically going to an appointment, correct?
That's correct.
So your claim is, and it's neurological, correct?
At this point, yes.
So you're punting with a back problem and anxiety and depression, and the judge wants to know neurologically what's going on with your spinal cord and your neck.
My lumbar, the L5.
Yeah. Okay. So what's going on with your spinal cord?
Well, there's notes of it being impinged in multiple places.
And?
My anxiety's kicking in. I'm a little not sure what the file says, really. There's a lot of notations about different things, from the stenosis, recess stenosis, measurements as far as there was a herniation, and now the disc has collapsed. It was diagnosed as degenerative disc, but that's just it.
Okay, so we're missing something from this equation, because if the judge wants to know neurological, then the judge is looking at how you're impeded and would be off task with the job. There's not a listing level that you're going to meet, which is why they're doing this to begin with. So you can't grid out because you're too young, so your vocational allowance. So what are we missing here about the neurological? Is your IQ lower from the incident? Did you have something where if you move a certain way, you get, fuzzy brain syndrome? Like, what am I missing here?
I'm not too sure. It seems I feel like it's standard. I'm just a patient. I'm sorry, I don't.
All right. So
that's one where this decreased disc height with broad-based disc bulging resulting in. Sorry, I'm trying to read the.
What I'm getting at is tingly hands, tingly feet, inability to go ahead and properly walk.
I have
brain
this,
dysfunction.
I have a rope between my ankle and my anus, and when I extend my leg, it's all numb and tingling. I fall down. I've documented falls with black eyes. I don't know how much weight that bears. The foot itself is tingly and numb on the L5 and the S1 nerve.
How many times have you been in the hospital emergency room as a result of falling, being a fall risk? Past 2 years.
I wasn't in the ER for falling, but when I was at doctor's visits, I did note it there for the surgeon. I've been in the ER several times for the disc issues.
You have special orthopedic shoes. They're supposed to help with the tingling sensation that are prescribed to you?
Not at the moment. I wear sandals because I can't touch my feet to put the socks on.
When your hands go numb, what happens when they go numb? You still grasp things, still do fine manipulative stuff like typing on a keyboard?
I don't have issues with my hands, unfortunately. It's just in the lower spine and the lumbar.
So your claim is going to be won or lost on the tingling sensations that you have in your, lumbosacral and lower area of your body. What does your medical evidence say about that?
I mean, I could rattle off what the surgeon.
What do the RFCs say? Yeah, what do the RFC letters say? Do they talk about the tingling, loss of function, loss of walking, loss of knee movement, leg movement, drop risk, that stuff?
A little bit of it. It seems more like a big box checklist where they kind of check boxes and then they say I can't lift things never. And
all right.
He added some verbiage to the bottom about tingling on the leg, but it wasn't very extensive.
Okay. All right. So that's where this is coming from. Proffer letter is basically proffering proof or evidence of some form related to the claim to show a judge something in some direction that will help, obviously, you win, some aspect that they're looking at. When it comes to this situation, to be very clear, the judge is looking at how you'll be limited for a vocational allowance, specifically if you'd be able to go ahead and do sedentary and light work. And so the idea is, could you at least walk, basically walk or stand for 2 out of the 8-hour day? And so the question then becomes, what do you need for ambulatory devices to allow you to do what you're supposed to do? The question I would have for you to go back to ask your attorney about is what evidence should you have in the record about the tingling sensations and neurological issues? And, how can you prove to the judge that these would limit your ability to work? Although if you have a big box, they're not going to do any writings. So,
I was trying to make a little mini brief of my own to kind of highlight some of these things for the ALJ, just in case my big box rep. I mean, there's a lot of mention of current radiculopathy. I'm not sure to what extent. Does the notes have to indicate directly the tingling and numbing, or do they just have to mention the radiculopathy and my testimony can count?
So one of the things that a lot of people don't get is that the disability, judges need bullet points to specifically put into the brief. And it can't be something where they have to really jump with their drawing of a conclusion. It has to be something where they can grab the bullet point, throw it in as proof. So what you got to do is go through your record and pull out where there's proof of fall risk, of not being able to walk, of difficulty, basically, going to the bathroom, difficulty moving your toes, that stuff. That's what they're going to be looking for here.
Okay, I mean, I've covered my hand on stuff like that. A lot of the things I mentioned to the doctors just really weren't notated very well in a way that helps me out.
Yeah, I hear. But wait, how are we doing on time? We're way over. We're over double. Good, sir. I got to go to the next caller. I will catch you later. You have a wonderful, wonderful night.
Thank you,
sir. Bye-bye. All right, we're going to see. I went way too long on that call. That was like half the session. So I felt bad for the guy because honestly, he's in like the real close to getting the win. And also like, it's just not, they're not doing what they got to do to make it happen. So, but that's part of the spiel. Question, kosherish. Let me see what the question is. Hold on. Can you elaborate on the smoking cigarettes thing? At 53, I've smoked for 42 years, not half a pack a day, as my family is funding the one vice I have left. I mean, you got to get rid of the one vice no matter what. You can come up with any cute excuse you want. You can come up with excuses about how it's the one thing you love and blah, blah, blah. You can tell me a story about that. You can come up with another excuse about how, you've been doing it for so long. If you got off it, you'd be medically, going through anxiety, depression, withdrawal, it'd be terrible. Blah, blah, blah. As long as you make an attempt to follow the 1-800 quit smoking, yada, yada stuff that you can usually get for free in your state, then that the ALJs, the disability, the SSA, they like to see that. Continuing to smoke, though, is going to be more and more looked down on as government benefits paid to a person, even though they're your benefits, unless they're SSI, then they're not your benefits. That's a welfare gig. That's us paying taxes kind of spiel. But my point is, if you're smoking, they may not, that they're having a more aggressive stance against that going into the future. So just be aware, whatever cute story you want to have as to why you're doing it and why it's okay. It's whatever, do your thing, but at the end of the day, they are moving towards people not being able to get benefits as a result of smoking, because the smoking, it obviously hinders your ability to heal, hinders your ability to function, all that stuff. Because you're putting literally carcinogens in smoke into your body while charring up your lungs and creating that heavy feeling where you can't breathe properly. So it's like somebody is purposefully limiting their ability to not be disabled. It's just something, like of the vices, the smoking, the cigarettes, and the use and abuse, it's growing in more, they don't allow it. Now, of course, on the other side of the spectrum, you have people who are smoking pot, and judges are becoming more open and available to that as a form of treatment. But cigarettes don't fit into that little quarry right there. So, anyways, let's see what else is going on. Let me see if we got another. LF Drums. Let's see what's going on here. Hold on. He said, does SSA really use the grid out when you're 60 years old for SSDI, when you have depression, anxiety, and severe arthritis in knee? All medical evidence submitted to the SSA. Yeah, they use it all the time, because then it's just a medium work question. At that point, they don't even really ask, can you do other jobs in the national economy? Because at 60 years old, the expectation is that you really can't, unless the politicians can fix that. And by fix, I mean screw it all up. The point is, they grid a lot of people out at 60. It's commonplace. It's as long as the medical evidence is there, shows limitation, can't do other types of jobs, education isn't super high, there's no direct entry into the general work environment, stuff like that, then you should be, okay and rolling in that direction. Do we have any additional callers? Because I'm actually trying to go and get out of the chat and get out of the video before it's 2 a.m. so I can go to sleep. Any additional callers here? We got, or we're going to do the countdown. We're going to count it to crap. We got another caller. Hold on. All right. Next caller. Remember to go ahead and mute the video on your end so we can talk directly through the phone. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
I have a question. So for anybody who is under 50, I'm in my 40s, and I've been hearing commonly through a lot of these pages that under 50. So basically, my question is: if you're under 50, do you need to meet a listing? Otherwise, is it going to be major trouble for you?
If you're under 50, you have CAL's vocational allowances and listing levels approvals. You don't have grid outs as an option. So you still have 3 out of the 4 options available to you. But most people under 50 are not a compassionate allowance listing, because, that's where you're in bed. You're stuck with the bed, or you're terminal. Listings, unless there's like something that got real bad real fast, like a cancer, something where the mental went way off board, where, you saw stuff that, warped you, and you're living in a behavioral facility, most of the time, you're not pretty much going to the compassionate allowance listing level, or even the listing level, to be honest with you. Most people under 50 are going for the vocational allowances, but the problem is inherent with that. It is a bitch and a half to get somebody through with that, because, remember, the most simple jobs they compare you to at the sedentary and light and medium and heavy and very heavy levels, all those, I mean, they're in the book, to say somebody can't go ahead and put stickers on items, for sale stickers with the price on them. A lot of people can do that when they claim that they can't. A lot of people can do that. Or, for example, a ticket taker job, you're standing there, you grab the ticket. A lot of people can do that. What's happening as a culture of this entire system is that, basically the world of, people being able to like go and have fun on disability benefits is over. The disability benefits have reduced in value over the past 20 years, so that they're worth hardly anything. You can't even really pay rent with them. So financially, that world is ending. The world where you could be found disabled with relatively moderate severity evidence is over. It's just over. They have computer systems that scan the decisions that the judges write, and basically scan the actual medical documentation, the entire file. and they'll send it right up for a appeals counsel review to say, hey, the judge made a mistake. We noticed this, we noticed this, we noticed this, and it wasn't mentioned in the actual decision letter. So like a simple version of that is like, it'll scan the medical evidence, collect all the doctors' names and see if the ALJ's decision actually mentions all the doctors' names. So, the world of being on disability benefits, because if you are just a person that doesn't want to work, whether it's for whatever reason, you had trauma, maybe there are lazy people on disability benefits. People, I'm not, they're on there. I know them. That world is ending, and it's only going to be, and I'm going to be very fair with you. I remember about 5 or 6 years ago, I was talking with an administrative law judge who was just getting ready to retire, and he was talking about the bin system. And the bin system was everybody basically, 0 to 18 or 22 goes in a bin. Everybody between that and 50 goes in a bin. 50 to 55 goes in a bin. 55 to 60 goes in a bin. 60 plus goes in a bin. The bin system is what they started using 5-6 years ago. To really break down which claim goes where and which ones are going to fit into what system. So in the future, the rarity of being found disabled for an individual that's under 50 is going to be very, very extremely rare.
Okay, thank you for your time.
Yeah, absolutely, sir. You have a wonderful night.
You too. Thank you, sir.
Thank you. Bye-bye. Okay, so I'm going to go ahead and end the video because we're at 26 minutes. Unless there's another caller. Hold on. Here we go. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. Remember to mute the computer or cell phone on your end. What is your legal question? And go ahead.
Yes, hi. My name is Nancy, and I have a question.
Sure.
I became disabled 9 years ago from a car accident, and I did my trial work period of probably 2017, and started out. I did 3 months of full time, then cut it down. I ended up working for 3 years. In the end, I just kept it part time because it was too hard on me physically. But what I wanted to ask was, because I know I didn't handle this right, when I started the job, I wrote a letter to the Vice President of Human Resources and asked for accommodations under the ADA, and I asked for a response in writing, and they wouldn't give me one, and they wouldn't give me any accommodations. And I know I could have maybe contacted a lawyer, but I figured what would be the point, because they'll just find a way to fire me anyway. If they said, okay, we'll give you some accommodations, but, and then they just find a way to fire me. So I guess how would I handle that? How should I have handled that?
So the question is, hold on, let me get this thingy. So the question is, sorry, my brain was kind of a little bit all over the place because it's super late. And somehow this thing is still ringing. Hold on. Boop. Okay, there we go. So the question is, you knew that, the job was going to go to hell. You wanted to get more hours. You wrote to the head of the, HR department. They didn't really do anything about it. What can you do now? Or what should you have done back then? Correct?
Right. I mean, I'm not looking to do anything now, but how should I have handled it back then if they didn't want to give me reasonable accommodations?
Okay, so first thing is, did they ever contact you back with their HR department about ADA allowances, accommodations, stuff like that?
No. Nope.
Okay, so you can file a complaint against them.
Yeah.
Did you ever begin a complaint? Did you do anything about it, or just kind of die on the vine?
No, I didn't do anything about it, and I just wondered, should the situation arise again, I want to handle it correctly.
So, all right. So
it was a job where I would be standing up, and I can't stand or sit for very long. But I asked for reasonable accommodations under the ADA, and then I gave some examples of what I thought would work, and then I said, but I'm open to any suggestions you may have. And they wouldn't respond in writing, and wouldn't basically. My supervisor was like, yeah, we'll put the chair around the corner and you can take as many breaks as you want. And then, they put the kibosh on that too.
So what I would say is this, All right. First thing you're going to do is Google work accommodations that you could potentially receive. That way, you at least you can make a giant list of 10 to 15 work accommodations that would have helped you. Then you can go ahead and I mean, I understand you're not going to do anything now. And I understand this was back in the day, but you could have, filed something against them, and said, hey, look, I should have had the opportunity to go ahead and receive some form of accommodations to be able to do this job. But going forward, what you normally do is if you're not getting a response from HR, you send it up to a higher person. If you're still not getting a response, then you go to the federal government to file a complaint against the recipients. You can even file a notification with the SSA. And then basically go forward. But what you were really looking to do is not piss everybody off and just be able to continue to work at the job. So, so what I would say, yeah, I mean, you never even got a response from them, so they didn't even have like a chance to like, really, like tell you what's up. So this is kind of a weird situation because almost always like people get a response of like, hey, we can't do this, we can do this, we can do this, we can't do that.
I got a verbal response from my supervisor.
What did he say?
So it went from the vice president of human resources to the department manager to my supervisor, and they said they're not willing to give you any accommodations.
Was there any reasoning to it or no?
No, that's all. That's the only explanation I got. Because I wear a brace, I walk with a cane, and so it was hard to stand up for 8 hours. So nobody sits here. So and they weren't even willing. So I just and I know I could have made a complaint, and maybe they would have decided to give me a reasonable accommodations, and in my eyes it would have been like, okay, well then they're just gonna I'm just gonna be a target to get fired.
Where did you go and work with after them? Where did you go and work with after them? Or where did you go to work after them?
I haven't. I was working. I worked part-time after my 9-month trial work period, and that was COVID, and I worked at a casino. So I never went back to work after that.
Okay. So you weren't really planning to work even going forward after that. So this is a thing where you kind of just gave up and didn't work, correct?
Well, I worked there for 3 years. So, I tried my 9-month trial work period because I tried to work full time, and then I just reduced my hours. And in the end, I ended up working 2 days a week, and I did that for 3 years. So, I mean, I just wondered how I should have handled it. That's all.
See, if a judge were looking at this, they would say, hey, you stopped working. That was it. That ended. So, did you have any jobs that you applied for thereafter or no?
No, because, it was COVID and, everything shut down. And, I didn't go back to work. I mean, it was very hard on me physically. So,
okay.
To the point where, they provide handicapped parking, but it's a 10-minute walk, and I could barely walk to the handicapped spot, Anyway, I was just curious.
Okay. All right. Yeah. But it's an interesting situation. I hear you got the verbal response, but, normally you would send in a formal written response after receiving a verbal response and asking for a response in writing thereafter. But, all right, let me take the last caller real quick.
Thank you so much.
Yeah.
Thank you so much. I really appreciate you.
Absolutely. You have a wonderful, wonderful night.
You too. Bye-bye.
Thank you. Bye-bye. All right, I'm going to take this one last caller, and then we're going to bed. Here, hold on. Boop, boop, boop. I'm calling it. All right, let's see if we can get this person on the phone real quick. Let's see what we can do. I'm hoping we can get this person on the phone. Let's see if we can get him on the phone. Hi, this is Attorney Walter Hnot. We are live. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Tony. My name is Tony. I saw your other video about the changes to Social Security.
Sure.
About qualifying for a waiver as well as the asset limits for SSI.
Mm-hmm.
How do I go about applying for the waiver since I qualify now for the waiver of my overpayment?
Well, I mean, so here's the thing. What I would do is, if you know that you fall into one of those, I would get an SSA 795 off of Google. It's just a PDF, SSA 795. I would go ahead and basically, with it, go ahead and write out your story as to how you meet those things and how you're requesting those things, and then submit it to the SSA and the local field office and see what you can do about, essentially getting them to process it. They're kind of going through things right now. They're reassigning most people in 2025 to go back to, basically CDR reviews and underpayment, overpayment. So they probably won't get to it until 2025, but that's what I would do. I would 795 and explain in proper detail exactly what's going on.
Okay. Also, qualifying for the SSDI with work credits, you have to have 10 credits in the last 20 years. 20 credits in the last 10 years to qualify for that, right?
Yeah. So basically, you got to have past 10 years, 20 QCs, and the whole idea is that, inherent with that means you've been recently working. Now, if you don't have that, you can, get somebody that has a place, a business, an employer, and then you can go ahead and work with them a little bit here and there. But that's kind of how you get your quarters of coverage if you don't have them.
Yeah, because I stopped working when I first got SSI in about 2013, and then I got cut off in 2019 because of one of those CLRs, whatever you call it.
Sure.
And, but the new asset limit, you said the new asset limit is like $6,000 plus $1,200 for each dependent?
No, I thought it was, it was, I have to go back and look at it because it's a brand new rule. I think it was 10,000 for the couple, maybe 3,000, 6,000 or something for the single. But that's purely for the overpayment situation calculation, not for SSI resource base.
Okay, so for SSI resources, I guess I watched the video wrong. The asset limit didn't go up for SSI resources?
It's different. That's the thing, is it's different. Because remember, traditional SSI is still 2,000, 3,000.
Okay, so that never changed, eh?
That part didn't change. So, all right, look, here's what's going on. Politically, they don't want to have to deal with SSI overpayments anymore. They think they're bullshit, and you guys don't have money to pay it back anyway, so it ain't going to happen. So the point is, they're probably going to pass across the board, basically, 5,000, 10,000, or 6,000, 10,000, single couple parameters for SSI. That's what they're probably going to do. But remember, O'Malley did this as his last step, final thing released days before he left he's leaving the SSA right now. That was the final thing done by O'Malley. So if the Republicans come in and they say, we don't want a bunch of SSI overpayments because they just clog this shit up, you know what I mean? What they'll do is they'll go ahead and, they'll probably go along with it. But remember, we're seeing a bunch of stuff right now that is happening because we got a really, really good commissioner in who just changed a bunch of stuff before he left as his congratulations, thank you for playing part of his Social Security run. So, if the Republicans are smart, they'll pass this through all the way for SSI. If the Republicans aren't smart, they'll continue their war against Social Security benefits and piss off a lot of people. Okay.
So it could be repealed. It's not a law yet or into effect yet?
No, it's an effective immediately as via the advocate page. So it's in there.
Right.
But remember, these things can be pulled back with the new party coming in. But I doubt it will. You know what I mean?
But for the waiver, you say just download the form and go ahead and put it in right away and see what happens, eh?
I would get the SSA 795, submit notification as to how you meet, equal, or exceed, or whatever the requirements are, and then kind of go from there and see what they say. Because remember, they're sick and tired of these SSI overpayments, and most of them are caused because of violation of the resource limit.
Right. Okay. Well, that's what I'll do. Well, thanks for calling me. I appreciate that because I was thought you at the end of your show. I had to call back all the time. I didn't want to bother you.
Yeah, no worries. But I'm going to go to bed. I will catch you later, good sir. You have a wonderful, wonderful night.
All right, you too. And thanks again for your help and your answer my question. Take care.
Thank you, good sir. Bye-bye.
Bye-bye.
All righty.